I'm Andy Hallaby, Snell and Wilmer partner in our Phoenix and Los Angeles offices, practicing in intellectual property and technology litigation. President Obama has now signed into law the new Federal Defend Trade Secrets Act, or DTSA, which was advanced by Congress with virtually unanimous support from both sides of the aisle. The new law is effective immediately. We are delighted to speak to you briefly about this new federal legislation and just a few of its impacts on trade secret protection.
I'm Tricia Farmer, an attorney in Snell and Wilmer's Phoenix office, where I focus on intellectual property and technology litigation. The DTSA's enactment marks a substantial expansion of federal court jurisdiction, with weighty procedural implications for litigating trade secret cases going forward. Consider, for example, that the existence of a DTSA claim now presumably allows a plaintiff to assert supplemental state law claims and/or common law tort claims in federal court as well. Thus, for example, the very substantial differences that exist between the initial disclosure requirements of federal law under Federal Rule of Civil Procedure 26A1 as opposed to the California Code of Civil Procedure or Arizona Rule of Civil Procedure 26.1 at the other end of the spectrum must be considered.
I'm Caton Vakil, a partner in Snell and Wilmer's Orange County office, focusing my practice on intellectual property law. California law requires identification of the plaintiff's alleged trade secrets before discovery. No express provision of the DTSA contains that requirement. It will be interesting to see whether federal courts adopt one through the procedural rules or by case law. Other procedural aspects of the DTSA's adoption worth considering include federal versus state differences in pleadings requirements, the scope of permissible discovery generally, and the treatment of draft expert reports, among others.
I'm John Lomax, a partner in the Phoenix office of Snell and Wilmer, and my practice focuses on labor and employment disputes. Many trade secrets disputes arise when one or more employees exit or change jobs from the company, and those employees have had access to company trade secrets. In that context, among other things, some noteworthy features of the DTSA include the narrow treatment of the inevitable disclosure doctrine, protection for whistleblowers who disclose trade secrets to the government or in court filings, and a provision permitting filing under seal in some circumstances.
I'm Tiffany Brosnan, a partner in Snell and Wilmer's Orange County office, where I focus my practice on labor and employment law. Another important aspect of the new law is its civil seizure mechanism. The DTSA expressly permits ex parte seizure of property that embodies misappropriated trade secret information. Despite the stringent requirements for ex parte seizures, trade secret plaintiffs can avoid the uncertainty regarding such a procedure that may exist under state law.
I'm Robert Clark, an attorney at Snell and Wilmer in Phoenix, focusing my practice on intellectual property law. There are substantive aspects to the DTSA that are worth thinking about as well. Substantive differences from the Uniform Trade Secrets Act start with the definition of trade secret itself. As you can see, the definitions are quite similar, but not quite identical. Similarly, the definitions of misappropriation are similar, but not quite identical. Importantly, for subject matter jurisdiction purposes, the DTSA reaches only to trade secrets related to a product or service used in or intended for use in interstate or foreign commerce.
We will continue to monitor developments as the DTSA begins to be applied by the federal courts. Please feel free to check our blog at swiplit.com and our pertinent practice group pages here for new developments.
This is an interesting and exciting time in the trade secret space, calling for multidimensional thinking in the application of new and old trade secret laws to real-world business problems. As a law firm in our southwestern region, with states whose civil litigation procedures can vary so starkly from one another's, we look forward to considering the strategic and tactical alternatives the DTSA's enactment presents for trade secret protection.